we go. So we're on recording? Okay.
Yeah, I will just a few brief words. So welcome to our, I guess this is the last event of Belgrade Legal Theory Group in this semester. And today we have the pleasure to welcome our dear friend and colleague, Professor Hrafn. And I apologize, I hope you don't mind for leaving out your last name because I will surely mispronounce it.
No problem.
And shortly, just to introduce him, an associate professor of philosophy and law at the University of Surrey, as well as the Surrey Center for Law and Philosophy. Latest, or maybe the most important book, The Nature of Value and Value of Vagueness in the Law, and main interest, philosophy of law, philosophy of language and mathematics. Today's topic will be the shaping of law by normative functions, based on the distinction between the background conditions and its, what would you call it, like the causality as such, or in usual, like the causes of further effects. So without further ado, you have about 30 minutes for your presentation, and we will proceed with the Q&A. Thanks.
Sounds good. This will be a challenge. And the last two times I presented, I think I aimed for 30 minutes. I ended up with 40. So I'm going to try to do better this time. So, which also means maybe I'll skip some stuff, and then we can take care of the gaps. If they are important gaps, we can cover them in Q&A. So the idea is just to take a hard look at a family of legal positivist views. Now, it's not exclusive versus inclusive legal positivism. Two of the views I'm taking a look at in the paper are exclusive legal positivist views, Hrafn and Shapiro. And the other view that I sort of join in because it's my paper, I put my own view in there because I'm interested in this puzzle that I'll explain, partly because it affects my own view. And although I'm not an exclusive legal positivist, my arguments, the arguments for my view, share a sort of an argumentative structure with Hrafn and Shapiro's views. I just draw different conclusions, but all of these views, these three views, and I'll explain them a little bit more in detail later. All of them sort of at the foundation somehow in this explanation of the nature of law and what implications it has for particular laws, legal content. At the very bottom are functions, not only functions, the functions that law have, but these are normative functions. At least Shapiro's definitely is, Raz's arguably is as well, and mine could as well be. So what I want to do is, at least, even though there's some leeway for interpretation there, what I do is I say, let's say that all of these views really do endow law with thick normative functions at the bedrock and draw certain implications of that. It's not everything having to do with the nature of law is not anchored in these functions, but part of law is. And then the question is, the big question is, how can these views be positivist? Like, that seems wrong. Like, if you have an explanatory structure about the nature of law, it's not entirely conceptual. Parts of it are conceptual, but it's more of a metaphysical explanation. If at the bedrock, if you anchor your claims, some of the claims about, not all of them, but some of the claims about the nature of legal content in these normative functions, are you not forced to switch sides? I mean, this, before I get to the details of the views, nothing hinges on the details of the views, though. It's just about the structure of the kinds of the family of views, but I will explain them a little bit just to get us all on the same page in a moment. But where was I? Sorry, I detoured. I shouldn't have done that. Underslept.
On Raz's views and the functions?
Yes, yeah, okay, thank you, excellent. So if we go back to Raz's views, the oldest, Shapiro's view is, I mean, it's not old, it's not new, it's published sort of most robustly in 2011. My view about 10 years later. It's, but already when Rasp put forward his view, people were suspicious, like just the way I've explained this, like normative functions at the bottom, some implications, some claims about legal content that are anchored in these. That seems weird for a positivist. But that was sort of it was this sort of hunch or suspicion a long time. And then people try to make it more explicit. Where's the problem? As far as I'm aware of, it's not until Mark Murphy, who has a weak natural law view, that's sort of a positivistic view in some ways about what he calls the realization conditions of law, but he says there's more to law than that. It has defectiveness conditions that are inherent, intrinsic. And so that's where natural law comes back in, sort of marrying positivism in a way, but still a natural law view. But he basically said, look, this is awfully close to my own view. It doesn't seem tenable to have this view and be a positivist. Like, I mean, it's not quite this simple, but it was something like, I see no relevant difference between these views construed in this way and my own kind of view. I mean, they're slightly different, but the structure of them seems the same, or at least should be taken to be the same. So that brings me to sort of, before I go into the views a little bit more deeply, what's at stake. It's not just about labeling, it's whether there's a genuine metaphysical tension that's not just a tension, but actually a genuine metaphysical incoherence in these views. But also what we're forced to do, if it is a genuine incoherence, then we have to give something up. And there are different routes that different people have proposed to this kind of tension. So Mark Murphy, I think, would prefer that we just give up on positivism and we call ourselves weak natural lawyers, something like that. Emad Atik, Cornell, would want to, but he thinks we have reasons to reconsider the way we characterize positivism anyway. So obviously there's no tension. If you need, for the tension to be brought about, you need the explanatory structure of these views anchoring claims about legal content in normative facts. And then you need a characterization of legal positivism where you get sort of an explicit conflict. Right? So one thing you could do is just say, we need to tinker with legal positivism and make it more normative friendly. And he has an idea for that. He thinks all of us should do that. All of us positivists should do that anyway. And he might be right about that. I don't think he is. I think I answered that. His other argument, which we're not talking about today, through the paper in some way, at least for Shapiro and myself. But what I want to say, at least, is that if we have reason to reconsider our views in any way, that may be for substantive reasons, but not because of metaphysical incoherence. Now, the third way that's been proposed that would change our views is that we give up the normative facts, these functions that I'll give examples of in a moment, as I keep promising. These are, there are ways, so David Plunkett has illustrated one way in which Shapiro could make these normative claims, not really normative, but more normative from our point of view. So it's sort of bringing in the sort of Razian point of view machinery to some extent, and just suggesting that we turn the normative into mental states towards the normative. So we sort of get back into positivism that way. And I mean, as I said, we may have reason to do all of this, but what I want to do is to try to retain the views and suggest that actually, when you look more closely at the metaphysics, there is no incoherence here. And I think there isn't even a tension, but part of the question at the very end of the talk, or at least the paper, is kind of, what are the prospects? Now that I've solved at least the most pressing issue, are there ways to revive the tension? Because people will, I'm sure that some people will think that, okay, you may be right here, but it just means that the problem lies elsewhere. Like there's some other way to bring out the problem. And that's an open question that I am interested in as well. But to get back to just the core of today's chat, what are these views and how are they supposed to get into trouble and what's the solution? So this is the very short version. This is shorter, very much shorter than in the paper and shorter than I presented it before. So bear with me. So the idea is that, look, well, just to recap Raz's view in very short, like in nutshell, meaning nutshell. So law has a function, let's say, and I think he can, at least one way to interpret him is that this function is genuinely moral in a way, more political, that we claim, like law claims authority, genuine authority, and so it must be possible for law to achieve that function. That is something that's common to all of these views. Whatever function it is, we all think law needs to be, at least in principle, capable of achieving it, even when it doesn't. And what that means in part is that criteria of legal validity cannot incorporate moral criteria because that would defeat the function and make the relevant law in principle unable to achieve its purpose. So that just means that for him, the criteria of legal validity do not and cannot include moral considerations. Shapiro also argues for the same conclusion, but on slightly different grounds, but it's sort of a descendant view of Raz's. Law sort of becomes relevant when morality gives out. So we have very complex problems that come from living together in society, especially heterogeneous societies, modern societies in particular, complex, contentious, and at least in some cases arbitrary problems, or at least problems requiring arbitrary solutions in some way, but it may benefit me to favor one solution or push for one solution and you push for another. So although they're arbitrary, they're often hotly debated because it may matter for self-interest and other things, cultural upbringing, whatnot, religion. How we solve this is by a complex form of social planning. And this kind of social planning, again, like Razi thinks, would not be possible if it tried to just restate the issue rather than settle it. It can't rely on morality because the social planning is meant to solve what morality itself cannot solve on its own. So that means criteria of legal validity cannot include moral criteria again. So they're both exclusive legal positivists. What's important here is that they anchor these claims about legal content, the shape of it in some way. That's a metaphor, of course, but facts about legal content, what it can and cannot depend on, or what it must be like and must not be like, are anchored in claims about authority, like genuine authority, moral political authority, on the one hand, and on the other, the moral aim of law, this complex problem-solving mechanism. And my own view is very different. I'm not an exclusive legal positivist, but I think taking the authoritative, the purpose of authoritatively directing action seriously has other implications. For example, that it must be the case that laws express views about how subjects ought to react, how ought to act, and then where we have statutes and constitutional clauses, then that which may not, you could have a just pure common law system with just judge-made law, and that's different. But at least for statutes and constitutional clauses where we have these, which is almost universal now, I would say universal. Maybe there are systems that could be called legal kinds of legal systems that don't have anything but judge-made law. But anyway, on my view, when we have these statutes and constitutional clauses, it has to be the case for the legal content to be captured by Proposition P, that the legislature has enacted an event as something that has the communicative content corresponding to P. So, so different kind of view in many ways. they don't think this is a plausible view of legal content, and they are also exclusive legal positivists, which I'm not. So different in many respects, but we have this same structure. We derive some of our claims about legal content from claims about law's purpose, and the purpose that we have in mind is thick and robustly normative in some way. Now, the old way of explaining legal positive or characterizing legal positivism, or what used to be more common, is just that criteria of legal validity that cannot include, or either contingently, not necessarily does include moral criteria, or necessarily doesn't include moral criteria for an exclusive legal positivist view. Now, there's no way to derive real tension with these views. It doesn't generate on this characterization, but from 2004 onwards, with Mark Greenberg's influence, Gideon Rosen, Emad Atik, David Plunkett, Scott Shapiro in particular as well, all embrace this sort of new or more contemporary grounding-based characterization of legal positivism, and camps in jurisprudence in general. Like, what are the grounds of legal facts? How are they metaphysically determined? Are they grounded in social facts alone, or social facts and moral facts, or can they be grounded only in moral facts as well, partly, not exclusively, but partly. Now, there, I think that's when people sort of saw sort of Mark Murphy, Jonathan Crowe, George Duke. They had tried to make the tension in these views more explicit, but I don't think they really succeeded. And the means to really draw out an explicit contradiction or conflict only came with this grounding-based characterization. So the idea is that, look, if you derive metaphysically, if it's a metaphysical explanation from some properties of legal content, are anchored metaphysically in claims about moral, political, or normative in some other way, thickly, robustly though, more purposes or functions, then it does seem like, at least to some extent, the normative facts partly ground facts about legal content. And that's bad news for the positivist if we assume the grounding-based version of it. So, which is that even the weak one, not necessarily moral facts partly ground legal facts, because if we take grounding to be necessary, then like on these views, necessarily these moral facts ground facts about legal content. So there's conflict with even the weak way of characterizing legal positivism in this grounding and using a grounding framework. So that's how that's where we're at the moment. And David Plunkett is the one who's maybe made this most explicit, but it comes from a long line of suspicion turned into more theoretically potent explanations that have not quite gotten there. And this is sort of I think the best we can make the puzzle. Like, we turn it into a genuine conflict, contradiction in the metaphysical commitments of these views. Now, what to do? So in the paper, I can't reproduce the route here because it requires a lot of steps. So we start with examples from causation, causal chain structures. And we notice that there is a pretty distinct and interesting kind of causal structure where we have facts, in this case events with causation, where they affect a causal chain resulting in an effect, but they do not thereby also cause the effect. And the idea is to mirror that structure. These are called ennoblers, meaning that the structure where we have certain kinds of prior facts that affect a causal chain and make a difference in some way to the causal chain that leads to an effect, but they don't themselves cause that effect. That is the structure that I want to transpose over to the views under consideration. So I want to say to preview the argument, the role that these functions play on our views is, it's not entirely negative, but it doesn't lead to these facts about the function of law, be it to solve complex problems where morality gives out, or is it authoritatively directing action. What they do is they do more than block certain kinds of grounding, right? They block moral facts from grounding legal content. So there's a blocking, so there's a negative effect, but they also explain something about the grounding that does obtain between social facts and legal facts, but not in a way that makes them also grounding. So, but we need to get there first. This was a pre-statement of the conclusion. So what is this interesting causal structure? Well, it's something that we kind of all know when it's pointed out to us, but it requires a lot of hoo-ha to really draw it out, because it gets, it's sort of often doing work in the background, other stuff being more prominent. So take the most common example that's given, which is called bomb. So Billy puts a bomb under Susie's chair. Susie sees the bomb and she flees the room. Week after, she already had an appointment with the doctor booked for a health check. And then she's able to go to for the health check. She gets a great report. So she's in good health. Now, what happens here is that Billy's putting the bomb under Susie's chair makes her leaving the room, fleeing the location, necessary in order for the effect to obtain, namely getting a good doctor's report, or any report at all. But it doesn't cause it. So indeed, putting a bomb under somebody's chair is likely to undermine the probability, sort of it lowers the probability of the effect. And it certainly is not a reason why she got a good health check. So there are cases where this also involves failure of transitivity. So sometimes that sort of it is the focus of discussion, but for about 20 years, people have failure of transitivity has a longer, more mature dialectic. People have started to pay attention to this other part of the scenario only about 20 years ago. Steve Diablo and a few other people, Brad Scow, and then a couple other people more recently. So, but once we see it, we can see it in many other scenarios as well. Person A throws a rock at a window. That makes it necessary if person B is in a position to intervene and prevent it. That makes it necessary for the window survival that person B intercepts the rock in order for and then if the window survives, Susie's I'm switching names here. So person A's throwing the rock is not a cause of the window surviving. And again, failure of transitivity, but that's not what we're interested in. What we're interested in is that Susie's throw person A's throw made person B's intervention necessary in order for the effect that did obtain to obtain. So what happens here, I couldn't really have I don't want to put stuff on the screen, that would take too much time, but let's say these are arrows going from potential cause to potential sufficient causes to an effect. So what the ennobler does is it eliminates, usually in the easiest cases, it eliminates all but one route. But it doesn't. So what it does, it eliminates the routes. It explains why they don't exist, but it also explains now not this arrow leading from the cause to the effect, but explains the opposite, right? The necessity of the cause is for the effect is now explained by the same thing that eliminated the other routes. And that is the structure, motivated by these causal examples. And then I do a lot of stuff, intermediary steps in the paper. I do other grounding examples, both from other people that have wanted to do the same for grounding. And I produce my own, both causal examples and grounding-based examples involving also exclusionary reasons like RASes. So I just want to put, so what I do in the paper strategically is that I don't want to anchor things in one plausible example. I need it to be a very common structure in both causation, grounding, and practical reasoning. Because I want this thing, although it's a slippery notion, it's contested. Most people think it's real, but nobody thinks it's been studied enough. So I need to then show that actually this is really a robust thing. So the more I can do, the better within a certain word count. Anyway, so, but, and interestingly, also, these are all like stuff involving Susie and Billy and guns and, so we might think we're talking about theoretical explanations in general jurisprudence. That seems very different. So there's also another intermediary step, which is to say, look at natural selection in biology. The debate there is about the causal power, if any, of natural selection, the causal role. What does it do? Does it do nothing? Is it just statistics superimposed on stuff that's already there? Is it just natural deselection, just killing off stuff, just blocking? Or is it actually causing, like explaining why there are opposable thumbs and why I have them and why you have them? Like, how strong is it? And I think when we have this ennobler idea, there's a family of views in that debate that can be better characterized as intermediary between those who see a stronger role and those who see no role at all, or just a blocking off, killing. So, so we already have need, or there is use for it in theoretical explanations in science. So how does it look then for us? Like, let's forget my view for today's purposes and just focus on exclusive legal positivist views as argued for by Hrafn and Shapiro. So looking back at the arguments and not worrying about under-describing them, taking them at face value and just saying, okay, yes, this sounds right. And I don't think I under-describe these views in any problematic way, but I need to make good on that in the paper so that I don't open myself to that charge. But basically, it's that, look, here are the functions. Moral aim, authoritatively, or moral problem solution, authoritatively guiding conduct. What these explain in the first instance is why certain things, right? Certain things don't ground legal content being up here, right? Moral facts, no, they cannot ground. They are not a route, not a metaphysical route. So that's the same as in the causal, right? And some people I think the way we often talk about it is that it does nothing further. But I think when you unpack the views and you think about authoritative, the way we guide conduct, etc., we solve problems by planning. It does point towards social facts. It's not silent on how things are actually grounded. It definitely is very vocal on how things are not grounded, but it's not entirely silent on how things are grounded. But not in the way that explains it, how legal content is built. It explains how it has to be built. Again, like the ennobler in the causal case, right? Person A intercepting a throw or eliminating some other causal route, leaving one, and by leaving one route, saying, look, the effect, causal effect, has to be anchored in this cause now because of the elimination. It's something similar. It's not entirely analogous, but it's something similar. So it's not grounded in legal facts, or not grounded legal content facts, not grounded in moral facts, but they have to be grounded in social facts. Now, what actually does the grounding are the social facts themselves, whether we take those to be both the relevant rules of recognition, and then the sayings, doings, and mental states or whatever. Some people want to say, look, it's just the sayings and doings and mental states. The rule of recognition it's an enabler, so the other things are ennoblers. Enablers may or may not also be grounds. That's a point of contention that I don't have a horse in that race for this paper, so I don't care. I think it can vary. Sometimes yes, sometimes people tend to think either it's always yes or always no. Either it's a background condition or not. But I think I'm more, at least I'm attracted to a more flexible view. But it doesn't matter for the purpose of my paper. Those are the things doing the grounding. But what the moral functions, part of what they explain metaphysically, is why these have to be the grounds. But these moral functions are not thereby doing any grounding themselves. Just like with natural selection isn't doing any causal, it's not transferring any energy from one cause to the effect, etc. And in the causal cases that we have, where we start in the causal chain is not a cause of the final event, the effect. Now, there's a twist there. I don't think we have time to go into it. We probably shouldn't, but I think the weak natural lawyer will, I'll just explain it in 2 sentences, but not give the argument. So the weak natural lawyer, like Murphy, for example, would come back and say, look, you've already conceded that law essentially has these functions, and we can straightforwardly derive from these functions certain essential properties, normative properties that law has, namely that you've said law has to be capable of achieving the moral aim. That seems normative, and that's an essential property. And also, law can be evaluated with respect, like intrinsically or something like that, essentially evaluated as law with respect to the relevant moral functions. Another essential property of a normative kind. So, are you not thereby anchoring at least certain properties of legal content in these functions in a grounding way, not in this other ennobling way? Like, it may work for some of these properties of legal content, but what about these? And then the idea is to say, look, you're mixing, yes, I agree with you with the essential, but legal positivism is really only threatened if we're thinking of intrinsic properties. And the intrinsic properties are all attributed to world recognition and our sayings and doings. Those are the things that lend legal content its reality. It makes it up in the world, and it's these facts from which legal content gets its intrinsic properties, meaning which action types it relates to the subjects in a jurisdiction. Right? These are all coming from the social facts. These other, and those are the intrinsic property, essential intrinsic properties, and those are the ones that legal positivism cares about, or at least we care about here in the purpose of this argument. These other properties are essential properties for sure, but they're essential extrinsic properties, and we see these all the time. Not everybody thinks they exist, but enough smart people do. Like you and I coming from specific parents, that's not an intrinsic to us, right? It's essential that I come from my parents, but it's not an intrinsic part of me. Like it's not a part of how I'm constituted. It's an essential property of mine, but an extrinsic one. And then those who are friendly to these kinds of properties see them quite frequently all over the place. Others are more conservative. What matters is they probably exist. I'd say they do for sure. But if I'm more cautious, I'd say they're likely enough to exist for me to have a good reply to Murphy. And nobody, Raz, Shapiro, myself, would deny that law, even legal content, specific legal content, not just law as an institution, have properties, essential properties that are extrinsic and have to do with the moral function that we've said exists in the first place. So we'd say, yes, this is exactly right. We're still not natural lawyers. And what's good about this latest reply is also that I can use that as a reply to those who think, look, ennoblers, they've got to be some sort of causes. You said they aren't causes, they aren't grounds. They got to be. Like they have what's called a no background conditions view. They say everything that is relevant to metaphysically explaining something, whether it's an event like in causation, or a fact more broadly like in grounding, or what you ought to do as in practical reasoning. Anything that's relevant to explaining this directly in some way, or directly, maybe indirectly, but like robustly enough, has to be part of the complete cause, the complete grounds, the complete reason. Raz had a complete reason view, for example, famously about practical reasoning and all that. So, and lots of people have this view about similar kinds of views about causation. Even more people have it about grounding. So I need a reply, and this was my reply also to these. So I'm doing quite a lot in the paper, and hopefully I've succeeded at least to give a plausible argument. So, but it's not meant to be the end of the matter. Like, hopefully, if I'm right, it's the end of this route to explaining the tension. And so either there is no tension, or it needs to be revived. And so I'm open to also thinking about how best to restate the issue in a way that's not just restating the hunch, saying, oh, we can't anchor claims about legal content in claims about moral functions, because that's the explanation. We need the why. That's the whole issue, and in a way that doesn't overgenerate. So it's easy to say, look, we can't mix normative facts and non-normative facts in this way. That seems weird. But again, that's like the converse of Hume's law, and we would have to give up, like we would have to throw out any possibility of naturalism about the normative. And so there are some strategies available that sort of come immediately to mind, but they really overgenerate, like they're way too strong. And so not really attractive to me. Thank you. That was a short version, believe it or not.
Thank you very much, Hrafn. Yeah, we've managed to be better than the last time when it comes to the time frame. So that's one step ahead. And now we can move on to the Q&A part. Anyone who has comments, questions, suggestions, you can step up. I have quite some. So maybe until someone else also comes up with a comment, I can proceed, or as they usually say, abuse my moderator role. Yeah, thank you. This was really interesting. And I've also read your draft version. It was a lot of fun, and the topic is huge. I think you cover quite a lot. And I will try to restrain myself on a few things. Although you have mentioned, in some sense, answered a few of my questions in your presentation as well. So basically, first of all, I do agree that I think, relatively recent attention to the functions of law is quite essential. And I agree, at least this is my stance as well, as was Ken's, if I remember correctly, and yours, that to have a full account or a complete account of what the law is, we have to include the question of functions, especially since law is an artifact and so on. And usually we talk about, we can also, I guess, empirically somehow conclude that those functions have to do with morality. I mean, we cannot avoid, I think, at least morality as connected to law's functions. And I also agree with your analysis when it comes to causation. I think it's subtle enough. I think it's sophisticated enough. It makes sense to make a distinction between the background conditions and ennoblers, enablers. Of course, I also wanted to ask, where is the thin line that we have to draw between the multiple and numerous factors within any causation, especially since I'm thinking about that regarding free will and stuff. But you've answered that there is no robust line we can draw, and we have to make something at least intelligible when it comes to this basic distinction, and I would say, fine, it's okay for a concept of a causation to do so. But on the other hand, I'm wondering about the implications of what you've suggested, because my first question in this sense would be, how would you account, for example, for Finnis's understanding of law? Because if we have to account for functions, and this is definitely a normative fact, and we can talk a lot whether or not we can be descriptive about those things and in which sense, you know, the theoretical creativity and so on. But when Finnis says that law, in essence, has the function of enabling the flourishing of people's personalities and so on, would the consequence of your distinction in the causality tell us that everything can be somehow made positivistic in this sense? I'm just wondering, how would you somehow characterize all those aspects of something that we usually qualify as non-positivistic, if you use this technical solution to the grounding problem in any sort? And the second question connected to this one is whether or not you think we're somehow, by doing this, maybe shifting the focus from the essential questions of what do we do with the functions of law? Because if, and I'm talking only about this in relation to the positivism, non-positivism distinction, saying that if we have to account for the functions of law, aren't we somehow asking of legal theory and our characterizations of legal theory to be a bit more inclusive in all sorts of aspects, by saying that we have to account for a function of law and it's connected to morality? So maybe the question is whether or not we should at all talk about the exclusive positions as such, instead of using this technical solution for saying that this stays within the boundaries of legal positivism. I don't know if I was clear enough. I'm sorry, it's a bit chaotic.
But it's clear enough, but it's a tricky thing to formulate. So there's a lot in there. So I think I can do better. I can do better on one aspect of your question, and partly just because the second, like the stuff about Finnis and what do we do with natural law and Greek natural law in particular. And then your second question was basically just a huge question for general jurisprudence that I don't know the answer to, but I would like to think with you as much as possible. But I have some ideas, and maybe we'll get to them, maybe not. But let's start with Finnis first. So one of the things that I've hoped to avoid in the paper is to address partly just because the paper already does a lot, and there are always going to be objections. So I've sort of picked the objection, Murphy's objection, which is the maybe the most pressing one, at least pressing in the sense that it's like right there, you have to address it. And then I've kind of maxed out my word count. I have a little bit of elbow room still. So that's why I'm doing these, I'm doing a lot of these presentations in May and June to see which questions I get. And on the way over here, I was actually, I hope I don't get the Finnis question. So it's basically.
Sorry.
No, yeah, good, but it's great. It's I need to say something, even if it's just a footnote. But it really is it's a worry, and it's not a worry. So it's an overgeneration worry. So it's like my account seems to overgenerate or undergenerate natural lawyers, underproduce natural lawyers, and so in a way, I mean, in some way. So one of the I confess I don't know what to do. So, but I think I will know in a few months' time what I find most attractive. So. One of the reasons is that I keep being unclear on how to think about Murphy and Finnis and where the real difference lies between Rash, Shapiro, Gardner, myself, and others, and Greek natural lawyers. And I don't feel bad about that because all of them also weren't sure, and they've tried to talk about it. And as far as I know, I mean, I find it unsatisfactory, but I think we kind of left this discussion where we thought, well, we're kind of the same in the end, but I mean, that's not quite true, but and the views all have very different exact contours and content, but in terms of types of views and argumentative strategies, etc., they share enough similarities to look very similar. And I think Gardner, I don't know if Murphy agreed with him on that, but I've seen Murphy say things that seem to echo agreement with Gardner on that. Well, our real difference is actually that natural lawyers, because of the way of the particular, not because of the general argumentative strategy, but of the exact content. They think that even if law, like Murphy calls realization conditions, what I would say is the actual grounding, is just social facts. Once we couple the social stuff with the moral stuff, as we should, and even exclusive legal positivists, that's what happens in the end. Like when we take a look at everything, we have to couple the social facts with the normative facts and see what happens. And then the natural lawyers, the weak natural lawyers, will say there's a positive presumption in favor of the authority of law, whereas the exclusive legal positivist would say there's no such thing. Now, I think there's probably more to it. So I like Leiter's pushback against Shapiro. It's unpublished, but he's coming out with something in the fall or something, or next year, something similar, where he says, look, this grounding stuff is, I mean, I think he's overshooting it a little bit. I think there's lots of stuff in the grounding stuff that's helpful, even if it's just to explain the structure of the metaphysics better, and dispelling problems like I hopefully did today, or at least a good attempt at. But he says, look, focusing on grounding and this metaphysical determination stuff is really sort of both obscuring stuff and also ignoring other disagreements between positivists and natural lawyers. And I think that's probably the same. I think the camps in general jurisprudence, the landscape is much too varied, too heterogeneous to be captured by the clean lines that we've been trying to capture them by. So it has to do with methodology. It has to do with metaphysical determination. It has to do with epistemics, how we can reason without reference to moral facts. Can we not? That's different. Criteria of legal validity as well. So I think we need all sorts of different notions to come together, and then each view has a combination of these, and then they're more or less similar to another view. I think that is better than trying to draw these hard lines between different camps and try to figure out which is better. So that's my answer to the Finnish concern for the moment. The other stuff, how do we tackle like the need to really focus on? So functions. I mean, I guess we all need to, so I think Emad Atik, I think he says, yeah, like even Hardian positivists, even those who, like you have to be pretty hard line to not associate law in some robust way, some necessity like way with normative stuff. Like that has to be pretty extreme. And just any talk about rule of law, you're already there. Even on sort of just focusing on formal characteristics, any talk about minimal content of natural law, I mean, it only takes a tiny step and you're already there. And most people would like, it takes a lot not to take that step. And so what Emad proposes in it's not out yet. It's on SSRN. It's out. It can be out in one of these RAS posthumous collections coming up. And he says, look, any legal philosopher who's not willing to take on the extreme, it will need to say something about goodness fixing. Law has to be a goodness. It maybe not a functional kind in a strong sense. So I think you're skeptical, and Ken definitely rejects functions in being out there in the world in a metaphysically productive way. I think Shapiro, I have stronger, and certainly Mark Murphy and Jonathan Crow and others, George Duke, functions are much more potent, like they're real fabric of the universe somehow. But even I think even the skeptics will have to say, look, it's still like Ken puts it in a way. How does he put it? The necessity is explanatory. We necessarily have to explain law with respect to it. That's not the same as, that's more about our cognitive abilities and how we make sense of things rather than track metaphysics exclusively. Anyway, so but still, that means law, even on his skeptical view, is a goodness fixing kind. Goodness just comes from us. We are fixing the goodness, but once we have fixed the goodness, we have to explain how it's fixed and what consequences come from it. Ahmad also thinks, well, it has more significant metaphysical, like he wants to draw, even the minimal picture has robust metaphysical implications for tokens, whereas I'm a little more conservative. I think doing minimally with functions also gives us very minimal metaphysical restrictions on what tokens of law or members of that functional kind need to be like. So for law, I think it's just, you have to relate the agent, the set of agents that are the subjects of jurisdiction, de re probably, at least that's I think how I prefer it, to an action type through some sort of modality, prohibition, prescription, etc. And that's very minimal. That's like saying, look, for a belief to be a belief, like it just has to be representational. It can't just be the referent of a proper name or whatever. It has to be, it has to involve a predication of a predicating property of an agent. Like it has to be reputational, and but that's a very low bar for what a belief needs to be, and that means sort of conflicting beliefs are still beliefs because they have the structure of representations, etc. So I think with law, it's also, that's my preferred. Now we're getting into other stuff that I argue for in different papers, but I think
I was just mainly pointing out the fact of which you also pointed out during the presentation as well as in the paper, that even though if we can call it an enabler regarding the normative facts, or in this case the functions of law, it's still explanatory in a very significant way. And that's what I was alluding to when saying this is maybe some sort of shift of focus to something which is essentially quite controversial when it comes to understanding laws for functions.
And for sure, I don't know if it converts. If I succeed, I don't know if I make people who want to be positivists but are worried about attributing functions less worried. They probably should be to some extent, but they probably would think less about I think it's more about substance. I think of all of these views, Hrafn Shapiro's mind, like if any of them are right, at most one is right, but they might all be wrong. But that would be on substance, right? So the question being, are there functions? Like, does law have functions, for example? And then if they are functions, are they weak, merely goodness fixing, or are they thick, robust, normative, like the ones that we have in mind, and that weak natural lawyers have in mind? I should say the natural lawyers, if you're a natural lawyer and you think that morality can be in some way sufficient for law, then that is a matter of grounding. So it's only
that would be the enabler, right?
That would be either I'm not sure, either enabler or direct grounds. It might be direct grounds. I'm not sure. Might be an enabler, yeah. But if enablers are grounds, then anyway. But yes, you're right. Then it does have this potent, direct, productive metaphysical role rather than this other one that is screening and then explaining something about the productive stuff, but not in the right direction in order for it to get us into trouble.
Thanks. Any more questions or comments, Jules?
Well, I had some of them. First of all, thank you very much for your presentation. You know that I come from a very empiristic, skeptical background. So for me, it is one of the comments that I had, and I will not project my screen to show you, is already like, do we really truly need to engage with this grounding thing? This was one of my comments. But you discussed about this when you mentioned, for example, Brian Leiter. So one of the comments was this one, because, for example, I think that there are ways to investigate law or to do jurisprudence in a wide sense that need not go towards the grounding preoccupations in the sense of one thing. So I think that the grounding preoccupation in some sense does away with the intermediates of the things. For example, you can just do jurisprudence by saying, okay, this is sustainable because there is some norm. That's it. And then you can have another investigation regarding what a norm is, or how can we say that a norm exists. I think this is something that comes because there is some type of jurisprudence that is interested exactly about how can we say that duties and rights exist. And I think that maybe this is something that we can put into consideration, whether jurisprudence needs to be about this. And I think that this is a question about if we need to engage with the grounding theory that has been going on in the latest years. This was my first comment.
Can we do
Absolutely.
one and then two? Yeah. So I mean, so first things first, I'm open to as I said, I'm open to the possibility that we're all wrong on substance. It's either wrong on methodology, like this is not the way to engage with in theorizing about law, or if philosophy of this sort is the right way to engage, we're doing it wrong. We're getting to the wrong conclusions, or we're presupposing the wrong things, or something like that. So I'm open to that. I'm just not open to the fact that, or to the charge that we are metaphysically incoherent in our views. At least, I mean, perhaps somebody else can persuade me, but I don't think that's the case. But in order for so what I'm concerned about, I mean, I'm kind of a let a thousand flowers flower kind of person. Like, we should be doing all of this stuff, and it's fine if we contradict each other on methodology, and there's just figure out, like, have plurality of approaches and see what they unearth. So one of my concerns, though, I mean, we always have concerns about the stuff that is not what we're doing, but somebody else is doing. So my concern is that if we would have to give up so it would be something like an eliminativist view. So we would have to, as soon as you start talking about legal content as a thing, as a category, as a type, kind of stuff out in the world, you sort of incur, either you need to explain sort of systematically how it relates to the stuff that where does it come from? Like, now, that doesn't mean necessarily that we have to start from armchair ground up. Often we might have a view about how legal content is determined, like what it consists in. Inference the best explanation, right? Something closer to scientific discovery. So, like, well, I've taken a look at everything that we can call evidence. the best explanation, I think that is most persimmon. Like we take into account all of the evidence and what it points to, plus theoretical virtues like simplicity. Probably simplicity is not a great virtue in law. It's way too messy, so it's, we should dial that down. Anyway, we find the right mix, and we say it seems most plausible here that the legal content is or is not, or it does or does not correctly correspond to its communicative content, for example. Like you might agree with me or you might disagree with my view based on inference, the best explanation, rather than this philosophical view starting from the functions of law. Now, obviously, we need to support our claims about functions of law in some sort of intuitive data, like evidence. And so it's not like we start from the bound, like sort of invent things out of thin air. But my worry is that once if you talk about the law or the content of law or at all or a norm, you already need to explain where it comes from in the world. Like if it's a thing in the world that you're referring to, even if it's in our minds, like how do we characterize it? So I think you're already in the metaphysics, and metaphysics is, I mean, thinking about who knows whether the specifics of grounding, all the specific stuff about asymmetry and like grounding may have lots of properties that are not relevant really and distraction, but that we should be thinking about grounding rather than supervenience, I think is quite uncontroversial, and that supervenience may help us test for things, and it may set explanatory constraints, but it's not explanatorily deep supervenience. It tracks modal facts about the thing in question. And just like many have been tempted to move from counterfactual modal definitions of causation to thinking about causal chains. And then counterfactual tests are tests for these causal chains, but the causal chains are what causality consists in. I think the same for grounding and including law. Like we can think about lots of things modally, for example, like what might be necessary, possible, and test that against intuition. But really, if you want explanations, we have to think about determination chains, which are that's grounding. And you might think like, okay, but minimally so. That might be fine. Some views will have more need for it than others. I don't think everyone has as much need as any other theorists for a sophisticated take on grounding, but certainly some do. And definitely, some of them come not from the positive side, but from the negative side, having to answer objections. So I acknowledge that if I put up a board of a rough explanatory structure that's supposed to be metaphysical, that has at the bottom normative stuff, and up here it has stuff about legal facts and content, facts about legal content, and I say I'm a positivist, people are going to look at me funny. So I want to be able to have a sophisticated answer to why that's actually not a problem. So I think, yeah, there's no invariable set need for metaphysics. It depends on the type of view, on the type of, are you building your view? Are you answering objections? But I'm I like Leiter's paper not because I go with him to his final conclusion, but I think it's a healthy reminder, which definitely you're on that side too, probably more extreme than I am though. That we should not get carried away, and that often the real differences and the content and the bite and the interest lie in other things than what we're focusing on for very specific purposes like grounding and stuff. So yeah. So you had another question though, you said.
Yes, I can write them to you because of the time constraints. I just wanted to say that I absolutely sympathize with your enterprise. I just come from a different side. And for example, when I started reading Brass, in fact, I remember when I was in Oxford, I remember asking Phyllis about this. because I was like, Ross says that he's an exclusive legal positivist, but then he assigns functions to law. And Finis was like, yes, 20 years I have been saying this. And I was like, okay, fair enough. No, but just a little comment about the function, because coming from this skeptical background that I come, I don't really see the problem with these moral things coming if you want to include them, because I think that it's not necessary for us to talk about morality in the sense of objective morality. If you consider morality in one, at least in our circles in non-Anglo-Saxon, it is called positive morality. That's it. The problem, I think, that is that these people that are sustaining these views do not, so they subscribe the unity of practical reasoning, so they cannot not say this or take in morality in this sense. But then if you go to towards morality in this sense, I think that the problem maybe does not disappear, but at least you have question marks about whether the problem is such a problem for example, legal positivists.
That's what David Plunkett thinks we should do. He's focusing mainly on Shapiro, but I think he would recommend the strategy for anyone having this kind of structure. Just like the normative stuff at the bottom, quantify the normative, and you can do that either with positive morality or just morality as seen by the people who were endowing the thing in question with a function. But again, Shapiro definitely doesn't. Raz, on the more plausible reading, doesn't. He is full on objective normativity. I want to be able to do so. If I'm pushed in the end to give it up, I will. But for now, I want to produce an argument, even if it requires us to do more to dispel worries about our positivist commitments. I want to retain the possibility of these functions being robust, like objectively. Objectively is a little, because you might have real morality that's not, you might have a constructivist view where you have, it's a realist, let's call it a realist view rather than objective view. So you might have a realist view. I'm taking constructivism to be a realist view here in the sense that it's real but constructed. So I want to retain that. But again, Plunkett is, he's kind of the person who's raised the puzzle most forcefully, and also spent a lot of energy trying to make attractive exactly the route that you suggested as well. So it's definitely an option, but I don't want to take that option since I'm not attracted to it. Like I'm attracted to the realist version of it, but if in the end that's not tenable for some reason, but I would take that to be that's a matter of substance, not internal coherence.
Sorry, I just realized there's a reaction for speeding up. It was an accident. I wanted to put the clapping hand.
I haven't seen that before. Funny.
Yeah, I think it's new. Funny enough. Jules, you wanted something else, or?
No, I will write to you with some other things that I have thought about it. Thank you very much for your presentation.
I had to do it once more. So yeah, thank you, Hrafn, once again. It was a pleasure, and thank you to the participants who are with us. So this is the last Belgrade Legal Theory Group meeting for this semester. I hope the next time we meet will be in person when it comes to Hrafn. So thank you once again, and see you soon.
Thanks, guys. Good to see you. Bye.
Bye.
Bye.